Firstly, we want to go back down the memory lane and start with when you were a student at HNLU and understand how your college experiences have shaped you as an individual. Therefore, we would love to know if you could share some of your most memorable experiences during your time at HNLU and how HNLU shaped you in terms of your legal career, especially your interest in disputes and arbitration, and what were the challenges that you faced as a student and how you overcome them in the following years?
Sure. Thank you for the question, Avni. Like in terms of the experience at the college, it was very memorable, and I thoroughly enjoyed my life as a student in the campus. Although it was a temporary campus, but we enjoyed it thoroughly, and the sentiments are echoed by all my friends and batchmates. And I'm sure nobody will say that just because it was Raipur, the first batch of the college, that we didn't enjoy. With being the first batch of the college, of course, comes with its own challenges. But I would look at it the other way around, that it also gave us a lot of opportunities for representing the college, whether it is a moot court or a competition or a seminar or a conference to attend, etc. So we always had the right of first refusal, if I may say it. So, to that extent, we had also the exposure to be taught by the best of the best in terms of the professors, quite seasoned, experienced, like late Professor G.V. Ajappa, who recently passed away, God bless his soul, Professor Jafar Hussain, Sairam Bhatt, Professor Shantakumar, Dr. Shantakumar, who is the Vice Chancellor of GNLU right now. And we are still in touch, like most of us who were close to the respective professors. We are still in touch with them, and they always encourage us, even at this time of our career, in terms of mentorship, guidance, and even otherwise, just a casual conversation about the family, etc. So that is the kind of relationships that we were able to build during our time at the college. And of course, like being the first batch, we had challenges in terms of not having a permanent campus. We were shifting hostels, etc. But at the same time, it had its own share of advantage because we were in proximity to the city. So therefore, it made it all the more convenient. So broadly, that is what I would say. And yeah, being the sixth in the list of National Law School, and being in a place which has comparatively less distraction, if I may say. And back then, when Raipur was a new capital, we had to literally explain to few people when we used to go out for internships that Raipur is a newly formed capital of a state called Chhattisgarh, and so therefore there were less distraction. We saw the first mall coming up in Raipur, so we have seen it all there. So to that extent, the distractions were less, so therefore we could focus and enjoy our time, rather each other's company. Social media distractions were also not there as much as we have it today.
Yes. What were like the major challenges that you faced as a student at HNLU? And if you could highlight any of those experiences that you remember quite vividly.
So in terms of challenges, again, as I said, like we had to actually explain to people that there is a place called Raipur, and we have come from the sixth in the list of National Law School. So therefore, establishing credibility was challenging initially, but gradually we were able to, with more and more batches passing out, we were able to overcome that challenge. And secondly, of course, with a campus where you have it to your own, it has its own set of advantages in terms of demonstrating credibility. People get to know about you. And so the law firms also, or organizations, institutions, when they are hiring people. So those advantages we did not have. We did not have a batch to look up to or a senior to look up to. Rather, we had to carry that mantle and be the torchbearer. So yes, as I said, so these were the challenges, but also it prepares you well that you do not have that advantage at the outset. So you will have to like help yourself and ensure that you create a path for the college like future as well and the future batches.
Yes, sir. Thank you, sir. Lakshita will go ahead with the next two
Sure.
questions.
Sir, we would like to know about your transition from a law school graduate to your practice in the actual legal field. So, how did you decide to specialize in dispute resolution and arbitration? And what was the biggest learning curve when you transitioned from being a law student to a practicing lawyer?
So first, I would say I was a pretty much an average student. With I believe I ended up being the 11th ranker out of a batch of about little less than 50. So with a 6.6 odd CGPA out of 10, I pretty much considered myself to be an average student. But I always like to be a jack of all trades, if not master of some. So what I did was that I made the most out of the 5 years in law school. I participated in moot courts. Like most of the batches, you would know that, and the reason why I chose that route was because that gave you the luxury of traveling to places, gave you more recognition within amongst your juniors. Third was because you could get attendance made up for your like traveling and preparation for the moot court,
So we
etc.
don't have that luxury anymore.
So we had that, and as the being the first batch, of course, you could negotiate a bit, and you had a better negotiating power then with the management. So that was one of the reasons. And of course, in terms of seminars, conferences, also I attended a lot of them. So the next thing I would say is that, and I do not regret having done that, because in terms of exposure, I considered, or in fact, like my batchmates also considered any internship opportunity that came our way to be extremely important from a career building perspective, because we had to establish the credibility of the college as also individual credibility, and find an opportunity for ourselves. So therefore, the work should speak for itself, and therefore we focused a lot on the internship opportunities that we got, and that to some extent I see generally amongst like law students to be like to have fizzled down a bit. In fact, to a lot extent, rather, I would say. There are the other aspects on which the students are focusing on, rather than missing out on this great opportunity of demonstrating your expertise, credibility before any prospective employer, if I may say. So that is one thing I did very take it up very seriously, and I thought that this is now or never. And therefore, in more than the academics, I focused on those extracurricular, and did my projects quite seriously, and converted about 20 odd converted my projects into about 20 odd articles by the end of 5 years. And most of it I started around third year, when I was able to decipher that that is important. So it was a pretty decent CV at the end of it, without any godfather in the profession. So these are some of the things which actually helped me understand the nuances of the profession. I always liked dispute resolution as a practice area. I never liked corporate law. And in terms of advice, I would suggest that one should not have a herd mentality. Generally, I see that if an honors paper is being offered, say corporate law, everybody just runs after it, and 85 or 90% of the batch would choose corporate law without understanding individual choices or likes, dislikes. I never liked or understood like the finance, corporate economics, etc. And never liked it. So therefore, I never chose, and rather took a path less traveled. I chose environmental law and intellectual property rights as my honors paper, where we had about 4 or 5 of us just in those honors classes. So that was a slightly difficult path, if I may say, because everybody thought, what do you do with intellectual property and environmental law? But ultimately I ended up practicing at some point in my career. I have practiced both the honors papers, though I do not practice those currently. But at least I am happy that I chose something for two reasons. One, for securing better grades, relying on my likes for a particular subject, because I enjoy trademark, copyright at least, if not patent. And environmental law was also like with the MC Mehta line of those environmental jurisprudence being established, and with Professor Dr. Kumar teaching us, I thoroughly enjoyed it, enjoyed my classes. It helped me improve my grades in the fourth and fifth year. So I must be honest about that as well. That was another reason I chose all these papers. Because if you like something, it automatically comes to you. And if you don't like, then you may struggle to get those grades. So since I liked both the papers, I scored well with distinction, outstanding, whatever those grades were. And that helped me improve my CGPA significantly by the end of the fifth year. So that is what is the problem, that everybody takes a herd mentality. So that is something which is best avoided, and you should choose where your passion is. And I was pretty much sure that I'll definitely not do corporate law, but I was not sure which field to choose. So dispute resolution it was. I enjoyed moot courts, arguing matters, etc. So with dispute resolution, at least you have that option to choose that as your career path. So that was predominantly the reason for me to choose dispute resolution.
Thank you, sir. So, if you were to revisit your law school days, what would you do differently to maximize your learning experience? And what advice do you have for current law students to make the most of their college life, both academically and personally?
So first and foremost, like I would not do anything differently, because in hindsight, like everyone is smarter. But what I would say is that I do not regret having missed out on anything. Like maybe I can say that I could have scored better grades if I would have focused more on academics rather than the moot courts. But the kind of person I was, the kind of personality I had, I was very much an introvert, which is like maybe a negative attribute or characteristic, if you may say, from a person who is practicing dispute resolution. But I could overcome that, and I give a lot of credit for that to my moot court exposure and experience. Researching skills again. With moot courts, one may say that you wasted your time, you could have improved your CGPA, but I don't think so, because the researching skills that I could build while participating in a moot court, or speaking at a seminar or a conference, or writing a project which I converted into an article sincerely, that is something which is invaluable. And I do not regret, because otherwise I could have been better off academically in terms of CGPA, but as a person, in terms of developing my personality, which was more important for dispute resolution practice, that I could have possibly lagged behind. So to that extent, I would not like to change that, whatever like I did for my 5 years in law school. In terms of suggestion, I would say that you should make the most out of it. Irrespective of wherever you go in your career, you would not get this 5 years ever. And the exposure which you will get, both in terms of academics, in terms of experiencing college life, hostel time with your friends, and like whatever mischief that you are into, or adventurism that you would resort to, you would never get that, irrespective of how much ever money you would like to spend. You will never get those. So those time that you spent in college, so make the most out of it. And at the same time, I would say that don't be someone, that is my way of looking at it. Somebody else may say that no, you should be scoring 8 CGPA, but as long as you have a decent CGPA with a all-rounded CV, I would, at least if I am interviewing, I would any day prefer that CV over somebody who has a 8 CGPA or a 9 CGPA, but nothing else. So it should be well-rounded, because these opportunity and exposure, that's not going to come back to you. So therefore, whether it be a conference, like Lakshita was mentioning about Jessup, Moot, etc., those experiences are invaluable. So that is something you should not miss out on. And if you should identify everybody may not be a very good speaker, but if you are good with research, you should go as a researcher. There is no difficulty. But in terms of exposure, you should not miss out just because you say that moot courts are not important, or you be judgmental about a particular aspect. Everything is important. It should be well rounded is what I would say.
So I'm just very curious to know what moods did you pick up, and like what was your favorite mood or experience that you had out of the moods that you did?
So I participated in about 5 moot courts, starting with the Surana and Surana Corporate Law Moot Court, where I participated as a researcher. That was my first moot court, and thereafter Henry Dunant I had participated in, and there was one more Commonwealth that I had participated in, and the last two were the most important in terms of experience. One was Maritime Law Moot Court by Murdoch University in Perth, and the last one was, I think, William Seavis, Vienna. So in all these subsequent moots, I participated as a speaker. In terms of experience, of course, William Seavis was overwhelming with the number of teams, the kind of judges. Like you see, you would have read their names as authors of important books which you have cited, and you find them as arbitrators judging your rounds. So that experience was brilliant and like very encouraging, and one must, if it's practically possible, one should experience that. And now it has become even bigger. And during the COVID, there were a lot of countries now, they organize this pre-vis moot, which I get an opportunity to judge. So the quality has improved significantly as I see when we participated in 2007. But in terms of experience, personally, my best experience was maritime law, because you don't have enough experts in India even then, and even now I believe there aren't enough number of experts. So we did not have the benefit of all these online portals, etc., which you have the advantage of right now. So we spent about 2 to 3 weeks in ISIL library and ILI library in physically in Delhi, where we actually started off. And we at HNLU, right from day one, we had a great library with OLIR and the journals and all that. So that was pretty good. And Westlaw Access, etc. we had. But of course, the experience at ISIL and ILI was very, very significant. So once we got an opportunity to spend that much of time on a field which is not typically taught in law school, and you don't find enough materials online, at least back then that was the position. And from an Indian perspective also, you don't have enough materials. It's mostly like UK and other jurisdictions. So that experience and the way we performed there was very, very encouraging. And what I did was that, at least that was thoughtful of me then, if I think of it. We were in third year, 2006, and since we had spent so much of time reading up about maritime law, I thought of applying for an internship. And I utilized that experience to write to firms in Singapore and in Australia, because we were thinking of taking a Singapore transit for the moot court in Perth in Australia. And coincidentally and luckily, I found an opportunity with a maritime specializing boutique firm. Sorry, it's called Cox and McNish in Perth, who was happy to respond to my email. I received a lot of rejections, but at least about 10 of them. And after that, I got an opportunity from Cox and McNish in Perth. So I went to Perth a month in advance, interned there for 5 weeks, and then I was joined by my team for the moot court competition. Sorry. And the experience which I got in the Australian law firm has remained with me and helped me significantly shape up as a professional by getting a comparative perspective of how firms function abroad and how to survive in a country all by yourself, because that was my first trip abroad all by myself. And the law firm people were also amazed by the fact that how a kid who is like third year in law school could travel like overseas and intern for a month. So that was an invaluable experience, and I give a lot of credit to that internship of mine.
Thank you, sir. I think that is a pretty cool experience even to hear, and I think a lot of students would find this idea very interesting to try for their future moot experiences.
And I was the first one to go for a foreign internship from the college.
Right.
So you have received numerous recognitions in your career. How do such accolades influence a lawyer's professional journey? What do you attribute your success and recognition in the field of dispute resolution to?
So see, those accolades and recognitions are just like those are part of the game, and one has to, like, it will automatically come in the usual course when you are practicing, and it's just about staying relevant. There are enough and more recognitions which are available, which can be bought, and I do not believe in all those. And all my recognitions in which I enroll myself in, those are based on client feedback or senior counsel feedback. So there are enough and more like such publishers who reach out to you and they say that you sponsor our event or etc., and we'll give you an award. So I just do not respond to them or do not believe in them, because if it is a paid recognition, it's no recognition at all. On the contrary, there are enough and more reputed publishers which are well known and followed globally. So be it Asian Legal Business or IFLR or Legal 500 and the like. So Benchmark Litigation, etc. So to that extent, it also keeps you on your toes in terms of the kind of matters that you are doing. So my belief is that those accolades and recognitions, those come in the usual course if you are doing good work for a consistent period of time. So automatically that recognition will follow, but one should not aim for those recognition and like forget about the fundamentals. So that is what I believe in, and that is what I have been following as well when it comes to those recognitions. And if you do good work, then automatically clients will recognize, because this profession, unlike many other professions, it is about word of mouth. So if you are doing good work, then automatically the word will spread. And in terms of business development as well, that helps you a lot. If you have done a good work for a particular client, then that client will definitely recommend you to somebody who is in need of similar kind of services. So that is one part. Second is these days firms and also clients are expecting a lot of expertise. You cannot be a generalist practitioner and you would expect that all the clients should come to you for every kind of work. That practice is gradually like diminishing. It's still prevalent in some pockets, but generally, if you ask me from a law firm perspective, we are also within the firm as a partnership, we are focusing a lot on and promoting individuals who are keen on demonstrating expertise in a particular field of law. So I'm not saying that you compromise on your fundamentals, or just just to give you an example, if somebody is interested in IPR, I would not recommend that you just go all out about IPR laws and forget about what a CPC says, what a contract law says, or constitution. So that extra specialization is never recommended, but there should be a good fine balance between the two, so that you should be able to appreciate the general part of it, which are important. And at the same time, once you have some level of experience in terms of general practice, then of course you can demonstrate, like you can keep one eye on your specialization even when you are doing general practice, and then demonstrate credibility in terms of your passion for a particular field of law. So if somebody says I'm interested in IBC, you should not go all out forgetting about the basics like a civil suit or a CPC or contract law, limitation, specific relief, etc. But at the same time, you should parallelly start reading up about IBC, read up judgments, write a lot on IBC, give your thoughts on new judgments or new positions of law, any amendment that has come up. So that way you are able to demonstrate your expertise and interest for a field which you like and you would like to focus on. But at the same time, in the process of extra specialization, you do not lose focus on your general practice. So that is something which I always recommend.
Right, sir. Um, Moving on to your insights into arbitration. So, how do you think arbitration has evolved in India over the years, and where do you see it heading? And what are the key challenges that have been faced by arbitration practitioners in India today? And if you could share any memorable arbitration case that you worked on, and whatever you've learned from that case.
Sure. Again, as I said, like one should be a good general practitioner and then decide on specialization. So I never thought that I'll be focusing on arbitration and employment in addition to my general litigation profile. I always was a general litigation practitioner in my initial years. But like as a general litigation practitioner, you automatically tend to do some arbitration matters, because that was the culture earlier, that it is the disputes lawyer, general litigation practitioner will also practice arbitration. And it used to be a post-court hours exercise, a high tea at the expense of client, and with minimalistic effective adjudication of say 15 minutes out of a 2 to 3 hour session. The remaining time used to get wasted at client's expense in high tea and gossip as to what is the talk of the High Court corridor. And the arbitrators, mostly retired judges, would talk about how they used to decide some memorable cases or their experience in the bar and the bench, etc. So it used to be all a farce, if I may say, at the client's expense. Thankfully, I have had the opportunity to see that part of arbitration, where the retired Supreme Court judge would call you up as the solicitor, making the arrangement for the booking venue, to also ensure that such and such items in the high tea menu should be ensured, so that the person can also carry enough for his grandchildren. So those were the days when I started practicing, and I was completely like taken aback by the experience and what I was witnessing. And post 2015 amendment is what I see that that was the turning point when it comes to arbitration practice. And post 2015, be it the legislative enactment, particularly no automatic stay, the introduction of 5th, 6th, and 7th schedule, read with the 12th, Section 12 amendment, with unilateral appointment, etc., being questioned by the courts for the first time. Third was the introduction of 4th schedule with having some guidelines about the fee structure. Otherwise, it used to be a pension plan for most of the retired judges. That is how it was perceived as. And n number of hearings with no discipline whatsoever in terms of timelines. It used to be a like what you call a more expensive affair than a court litigation. And with 50 hearings, 70 hearings, etc., and still not concluded. And even if you managed to get an arbitral award, that used to get challenged before a court, and it used to languish for years together. So that was the position. But post 2015, even the arbitrators, litigants, etc., everybody became very serious, and they realized that it is serious business, and you can't just be having 2 hours of post-court hour session. So the arbitrators, particularly I would say late Justice S.B. Sinha, was very, very particular when it comes to procedural hearings. He would make sure that he would follow the practice which has been followed in institutional arbitration for years, that 5 days in a row with morning 10 to 5 with 1 hour of lunch break, and serious business 3 hours session each on either side of the lunch break. And he used to make sure to comment that do not ask me for post-court hours hearing, or ask for unnecessary adjournments. I am going to impose cost. It's going to be serious affair. You either choose between court litigation or arbitration. and that practice was followed by some other arbitrators who were busy, and that practice has changed the shape of arbitration, where we inculcated the practice of institutional arbitration and ad hoc arbitration, because about 85-90% of Indian arbitrations are all ad hoc. And there is still a long way to go in terms of institutional arbitration. So at least when this was inculcated in the ad hoc arbitration practice, that made a significant difference in terms of discipline. Secondly, the introduction of timelines also made it serious business for the arbitrators and the lawyers. No unnecessary adjournments. And second is, if you had to exceed beyond the initial period of like 12 months, it could be done by consent of parties by 6 months. And then further, after the expiry of 1.5 years, one has to go to the court with giving sufficient reasons. So when you have to give sufficient reasons, the arbitrators were also mindful of their reputation of being in the bench. So that also brought in a lot of discipline. And these days, you do not see a commercial contract without an arbitration clause. And many a times you see multi-tiered arbitration clauses with negotiation, conciliation, etc., mediation preceding the invocation of actual arbitration proceeding. So to that extent, it is by far, according to me, the most successful form of dispute resolution mechanism when it comes to trans-global dispute adjudication. I'll just give you an example in terms of, for example, if you have a dispute between a US entity and an Indian entity, and there is no arbitration clause, you have to sue someone and get a relief from a US court to get a judgment and a decree. Now, there is no reciprocity arrangement between India and US under Section 44 capital A of the CPC, by virtue of which that judgment of the US court will only have a persuasive value. It is not automatically enforceable in Indian courts. So if you have to go after an Indian party and are representing the US client, then you will have to file a fresh civil suit in India, relying upon a certified copy of that judgment and decree. And you can imagine then your fate as a US client by dealing with the court litigation in a Indian court. So again, it is going to languish for years together. So the time and money that you would have wasted in the US court goes, like, it's virtually you are back to square one. Whereas by virtue of Geneva Convention and the more successful New York Convention on Enforcement of Foreign Arbitral Awards, if you get an arbitral award from a foreign like jurisdiction, for example, the same US arbitral tribunal, you can automatically enforce it in Indian courts against the Indian entity directly, and the scope for interference is very, very limited. And there is a myth surrounding arbitration practice that you are filing an appeal against an arbitral award, which is not correct. Rather, it's a challenge to an arbitral award. Even if you see Section 34 from domestic arbitration perspective, a challenge to an arbitral award is not the same as an appeal to a decree of a civil court. The scope of interference is extremely limited. Of course, there is still a long way to go, but particularly speaking from my own experience in Delhi and Bombay, the courts and particularly the original side jurisdiction, when the Bombay and the Delhi High Court exercise, they do not even hesitate to refuse admission of a Section 34 if they do not find merits. And they are insisting on deposit of 75 to 100% of the awarded sum, which is a big deterrent. Earlier, there used to be an automatic stay. Now, if you are asking for a stay on an arbitral award, you will have to mandatorily deposit the amount. And the successful party can also withdraw the money by giving some security before the court, be it a bank guarantee or a fixed deposit receipt, etc. So that has brought in a lot more seriousness about arbitration. So I would say that the situation looks much better, and with the proactive judiciary, post 2015 in particular, the scope of judicial interference, which is like very limited, and that has been the touchstone of like improving the scenario, the arbitration scenario in India. With the subsequent 2019 amendment and 2000, we see a bill also now around the corner, 2024, with some more changes having been introduced. So with proactive judiciary and the right legislative intent, I believe the future for arbitration is definitely brighter, and it is definitely a great practice area to choose when it comes to like if somebody is interested in dispute resolution. To coming to the second part of your question about a memorable case, I would say that that would be Voistal Pine versus Delhi Metro Rail Corporation. So, briefly speaking, the 2015 amendment had just been introduced. And in fact, the client Voistal Pine, which is an Austrian market leader which manufactures rails, they had reached out to us for this dispute with DMRC. DMRC was not paying their bills for supply of rails, which they had done for the Delhi Metro Phase 3 project. Now, when they reached out, I had the opportunity to, I was just examining Section 12 amendments and 5th and 7th schedule, and I suggested, why don't you consider challenging the panel which DMRC is proposing. So they were proposing a 5-member arbitral tribunal, arbitral panel to choose to constitute the arbitral tribunal out of the 5-member recommended by DMRC. So what I did, I sent out a RTI through an intern, if I remember correctly, and to DMRC asking who has the right to hire or fire those panel members. And the answer was like exactly what we had anticipated. And the response was that the managing director of DMRC has the right to hire and fire. So that formed the basis of a Section 11 petition which we filed before the court. After replying to DMRC, objecting to the panel, we said that we are not going to be bound by this panel in view of these amendments, Section 12 read with 5th and 7th schedule. There is apprehension of bias, reasonable apprehension of bias by the panel, because you are the ones who are hiring and firing them. And there is obviously a commercial interest associated with them, passing awards in favor of DMRC. So there is reasonable likelihood of bias. So we want an independent arbitral tribunal to be constituted. They refused as usual, as expected from a PSU. And we've moved the Supreme Court because Section 11 would lie before the Supreme Court, with one party being a foreign party, International Commercial Arbitration definition. So we filed it before the Supreme Court and we partially succeeded. Mr. Mukul Rothgi was then the Attorney General, and he came out with a 31-member panel as against a 5-member panel. Justice A.K. Sikri's judgment reported in 2017 for SCC 665. And in that, the court came down heavily on DMRC, saying that these obsolete clauses in arbitration should be set aside. And he set aside the arbitration clause, allowed us to choose from a broad-based panel of 31 members, gave directions to DMRC to constitute an even more broad-based panel with lawyers, chartered accountants, engineers, railway engineers, and retired judges, etc., so that a private party, and particularly a foreign party, when we are talking about foreign direct investment, etc., so the climate is not suitable in case you are having such obsolete clauses where you want to chart the course of arbitration by having some form of superficial influence on the arbitration proceeding. So those observations, so though we partially succeeded, but that was the first judgment in the line of unilateral appointment of arbitration proceeding. Then I had got an opportunity to argue for a PSU just on the very same point, which is again a reported judgment by Justice Rohinton Nariman. These, which is called as Marcus versus GAIL India Limited. So we were representing GAIL in that. So both these reported judgments like just ensured that I focus more on arbitration, and I had the opportunity to argue the arbitration proceedings end to end for the Voistal Pine matter. And also the GAIL matter, Section 14 was argued before the arbitral tribunal. We succeeded up to the Supreme Court. And the Voistal Pine arbitration also, that was argued and handled entirely in-house, and I succeeded in those two arbitration proceedings. So that these are two landmark judgments, I would say, which helped me demonstrate a lot of interest in arbitration. And then on, like I always enjoyed doing it. And from a young practitioner's point of view, I would say that if you like arguing matters, then arbitration is the way forward, because it gives you the opportunity to test yourself. Unlike a court where you can get away, because if there are 100 matters on the board, with experience you will get to know if your matter is 95, whether or not it will reach, and if at all it will reach, at what time of the day, and how much time the court will have to hear your matter. More often than not, you will be correct in your estimate if you have some experience in the courts. But in arbitration, when you have the whole day and the arbitral tribunal sitting just to hear you, you have no way to get away. So therefore, you better be well prepared. So meticulous preparation, attention to details, etc., those things are typically associated with arbitration. And with rigorous schedule, it keeps you on your toes, and a lot of responsibility, which many a times the senior counsel, because of their busy schedule, they are not able to give. And to a lot extent, the disparity between a senior counsel appearing in a court and a young practitioner appearing in a court, you may still have some disparity in some of the courts. That disparity diminishes to a lot extent when it comes to arbitration proceeding. And the arbitrators, the same retired judges, will tend to value your arguments and submissions way better if you are well prepared. That is what my personal experience has been, and that is the reason I enjoy doing arbitration matters.
Thank you so much, sir, for those insightful conversation, the memories that you've shared with us. I mean, I'm sure a lot of students would agree that even in terms of the internships that they've done and the differences that they've personally speaking they've faced at interning under a court, under a lawyer, under a counsel, and then going through the same sort of procedure in arbitration proceedings, and how the kind of work and the kind of research that differs in these domains are completely different, and how arbitration, even as we study it today in our courses, is sort of turning out to be an emerging field that is very fresh and sort of interesting for new faces who are entering the field and want to sort of go away from the old school court and the way that the court works. And arbitration gives us a very good opportunity to sort of go into that domain. So thank you so much for that answer. I think Lakshita can go forward with the second question.
So how does your experience as an arbitrator differ from that as a disputes lawyer? What qualities do you think are essential to excel as an arbitrator?
Thanks, Lakshita. Before I answer that question, one more thing I also must clarify. When somebody is choosing a course, choosing a career in arbitration, one should not be swayed away by the jargon, international commercial arbitration, and the fancy things associated with it, be it a 5-star hotel with conference rooms, with lavish buffet menu, etc., and which are typically associated with, or a good reputed institution, etc. One should obviously be a good trial lawyer first before jumping into an arbitration, because essentially what you do in arbitration is, it's a simplified version of a civil suit trial. So therefore, one should not lose focus from the basics, like the CPC, the Evidence Act, Limitation Act, Contract Act, Specific Relief Act, and most importantly, the Arbitration and Conciliation Act. So one should be familiar, if not like a master of these subjects, and the entire process and procedure which are typically associated with trial and civil suits, whether it is in an original side practice of the 4 chartered high courts, or trial court, which is the lower judiciary. Because if one jumps into an arbitration, will find it very difficult to adjust and adopt the practices which are associated. So while the CPC and the Evidence Act do not strictly apply by virtue of Section 19 of the Arbitration Act, but the principles do apply, and most arbitrators who have retired from the courts, they tend to follow the principles more strictly, and some may follow it in a less cumbersome or stricter manner. But at least if you are familiar with the practice and procedure, that makes the job much more easier. Now, coming to Lakshita's question about like acting as an arbitrator, so that role I believe is much more difficult than acting as a counsel because you can't take sides. That's the most important thing. And in terms of attribute, I give a lot of. In fact, the a person has to be a person of integrity, because what you are doing is you are basically substituting the role of a judge, and as they say that with great power comes great responsibility. So when you are deciding on rights and obligations, or rights, you are adjudicating based on rights of the parties, so you have a lot of responsibility, because your award is also going to be potentially tested before a court, and if it is not upheld on fundamental principles, then that is something which is discredits your entire experience and expertise in the field which you claim to be. So therefore, to that extent, one has to be extremely mindful of that. At the same time, try to adhere to the basic objective for arbitration, which is expeditious disposal and reduce judicial interference with less cumbersome and tardy procedures, which are typically associated with a courtroom traditional form of litigation. So, if you are able to do that, then that is something which you will be able to do your bit as an arbitrator in reducing the burden of judiciary, whatever little extent that you can. But for me, the most important attribute is integrity, because if that is lost, then there is no point in people reposing faith and trust in your ability to decide and adjudicate their rights and duties.
Right, sir. So,
Thank you, sir.
my next question would be regarding any advice that you would like to give to aspiring dispute lawyers. And I want this question to be phrased in a two-pronged manner. Firstly, what advice would you give to any students who are in law school right now, and they want to develop a career in dispute resolution, and how they can build their credibility? What kind of internships that they can go ahead to sort of build their skills or go ahead in this field? And secondly, in terms of the dispute litigation market that is present in India right now, what do you think, what areas of law holds the most potential for growth in the Indian legal field, and how do you think the market has changed for lawyers since you started your career, and what trends should the lawyers watch out for while progressing in their career?
So, as I said earlier, there are no shortcuts in terms of like it may be sounding repetitive, but at the same time, the lesser said, the more I say, I would like to reiterate that more often, because there are no shortcuts in terms of immediate success. So you have to be persistent about it, and persistent and without expecting much result in the near future. So for somebody, it may be a law firm job. For somebody, it may be a organizational position, or for somebody, it may be a practice in a with a senior counsel, or with a busy chamber counsel, etc. So it need not be one size fits all. You should choose what works best for you. You may be cut out for a good like litigation practitioner. So if you are spending time in a law firm or an organization and are not liking it, it doesn't make sense for you to pursue that just because, say, your friends or your best friends are pursuing that. So like you should identify what works best for you based on your areas of interest and your like characteristic and whatever you are cut out for. So that is something which I always believe in. And as I said, do not go by that herd mentality and choose whatever works best for you. You may not see immediate success. Say, for example, if you are starting to practice in a court, and your friend who has started off in a, say, tier 1 law firm. So while the emoluments may not match, but in the longer run, if you are persistent and you are patient with what you are doing, in the longer run, maybe you end up being a senior counsel and maybe earning much more than what the person is earning. I understand, like I'm not undermining the importance of earning, but at the same time it has to be a good balance of like what your passion is and how much do you need to sustain. So depending on that, one has to make career choices accordingly. Second, as I said, do not lose out the opportunity of enjoying the 5 years in law school. That's never going to come back, irrespective of how much money you invest or you are willing to shed. You will always talk about the memories that you have created with your friends and will always relive those memories. Then every time you meet your friends post passing out, and you will be staying, say, just across the road, but you will hardly find time to meet them up. Uh, like possibly, like that is my experience, and that has happened with me. So that's why I can say maybe somebody else may be much more social and meeting more often. But that is what happens. You may be close by, but stay in touch is what I would suggest, because what you are doing right now is going to stay with you forever. So the foundation has to be strong. At the same time, do not forget to enjoy by getting exposure to whatever comes your way, be it a competition, be it interacting with faculties, your alumni, or any form of experience, whether it is domestic or international. Uh, Next is, I should have highlighted this earlier, and would also like to say that if I have to give an advice to my younger self, I would have possibly networked better. That is something which is obviously we do not value the importance of networking as much as like now I realize in hindsight the importance of it, and that is something one can inculcate right from early days in law school, that if you are networking without any expectations, like just for being mentored, just for getting right guidance, interacting and like learning from people whom you admire, whom you follow, whether in terms of podcast, YouTube videos, or LinkedIn, etc., following their journey. That is something which was lacking when we were studying, because we do not did not have access to as much as professional networks or these and the COVID silver lining was this, that you had all these webinars or access to all those, be it a lecture by a senior counsel on a topic of your interest, or anything for that matter, or a subject matter expert speaking on a particular topic. So these are some experiences which are right now available on a click of a button and should not be lost sight of. The competition has increased significantly. Law was not a preferred course then, so comparatively the competition was less. So that is the significant difference that I see. And with mushrooming law schools, with the number of students like participating in CLAT more than the number of students in medical, as per some news reports which I had come across. So it is definitely a preferred course, and every second person that you interact with is pursuing or interested in pursuing law. So therefore, with the mushrooming law schools, the competition is all the more increased, manifold, and therefore one has to be like up for it, and has to make the mark in the market, in the sea of people who are passing out. Unlike in engineering, you do not have such a big market. Like for example, an IT company comes to an engineering college, takes say 5,000 people, hiring at a stretch. You have a limited number of law firms or organizations. So like even the biggest of law firms, like for example, ours in terms of Khaitan Company now is the biggest in terms of number of lawyers, with 1,300 odd lawyers. Even though we want to, but we cannot hire more than a particular number of students in a particular year. So that is very, very limited, and maybe will not exceed 2 digit. So to that extent, the competition has increased so much that one has to be relevant and make the mark in the market to be able to make that impression and get an opportunity at the first place. So the advantage is, with a NLU tag, you have the foot at the door, and without going into the NLU non-NLU debate. At the same time, if you are in an NLU, like whether it is the 5th or 6th, it doesn't matter. Being a brand ambassador of the college you have to capitalize on whatever is with you. You have chosen this. You had the option of choosing some other college, but you chose this. So therefore, I always believe that one should respect what you have in hand rather than cribbing about what you do not have and what are the disadvantages of it, be it a management, be it like the faculties, quality, etc. The quality has gone down like generally in law schools because there are so many more opportunities for the faculty members. So automatically it is good, the brain drain is going to happen and continue. But at the same time, you still are better off. For example, you have an NLU tag, and it is like out of, I don't know how many of the national law schools right now, 20 or 30, I don't know, whatever it is, you are still in the single digit with the 6th national law school. So one should make the most out of it. And you have a foot at the door, just that you have to capitalize it with experience and your own will. So that is something which one must pursue, and which I generally see lacking. So while the competition has increased manifold, but the quality of students has also gone down. So it's not about boasting, but we were more hungry. We were hungrier when it comes to getting a PPO opportunity, getting an internship opportunity, and we were much more desperate about proving ourselves in the market. Today, like I may be criticized for this, but I do not have any hesitation that when you are entering the legal profession, it's not a cakewalk. It's unlike a 9 to you. It's definitely not a 9 to 5 job. So if somebody says that I want, and I have heard these questions, and that's the reason I'm saying it. When I have been interviewing people, whether it is in a day zero interview or generally when it's a lateral hire interview, often some of the like candidates, they ask me whether I'll have a work-life balance. So the answer which I typically tend to give is that, see, this is a difficult profession, and if you wanted a work-life balance, this is possibly you are in the wrong choice of career options. And but at the same time, with a legal profession also, if you want a work-life balance, choose a PSU job. There are enough and many. You apply for those and choose. But if you are coming in a law firm and you expect a work-life balance, if there is client deliverables, then you cannot expect that to be, you will have to compromise. We have all done that. And to some extent, you have to compromise on your personal life. I'm not saying compromise in terms of the quality of life. In terms of, I would not recommend that you continue at a place having a toxic workplace or a toxic boss for that matter. Choose a good mentor. And if you are following your passion, like again, I'll take the example of if you are interested in arbitration and you are getting good quality work, which is giving you an opportunity to showcase your skills, then the timings that you spend in office or working over weekends, etc., those naturally should take a backseat, at least in the first 5 years of your career. And you should not be expecting a work-life balance that I don't want to work on weekends. That's not going to happen. A client you will find invariably will sleep over the whole week, will send out an email at 5 p.m. on a Friday evening, and will expect you to deliver on a Saturday. And in service industry, unfortunately, there is so much in the market, so much competition in the market. If I don't do it, there are 100 other people who are ready and willing to do it by tomorrow before the time I'm committing. So therefore, I can't afford to be. But if you are not aspirational enough, then it's all right. Then you can take a backseat. You can have a work-life balance, and at the same time, you can maintain a good balance. But if you are enjoying something, then I don't see those timelines, how much time you spend in office or how much time you are devoting for work. Those all become secondary and should not be important. Yeah.
Yes,
so
sir.
Those are my thoughts. Yeah.
Thank you so much, sir. I think we're running out of time anyway. So I think I would just want to ask you one last question. Sir, you mentioned about how you feel like the quality of work that has been produced by sort of the the young lawyers or interns for that matter is decreasing, and the competition is increasing. So there are two aspects of an internship. Firstly is the first part is getting the internship in the first place, and I think that is a very difficult process on its own. And once if you are able to overcome that, the second part is actually doing well in an internship. So what would you recommend? What kind of quality of work or what attributes would you recommend? What you want to see in an intern, especially if it's an assessment internship or if they want to convert into a PPO? What attributes would you like to see, and what kind of attitude would you want to see in an intern working in that position?
So 2-3 things on this. One, that one should not be like generally I have seen that the objective of an internship for most students is getting a certificate from an organization or a firm of which they have aspirations of. Like just hypothetically speaking, like everybody wants a tier 1 firm's internship. But just because you are not getting a tier 1 firm internship or a job doesn't mean that you are like anyway lesser as compared to your quality. So rather I would take it, I would put it in a different way, that like job opportunities have gotten difficult with the number of students passing out, internship opportunities have also like lessened because of the competition. So there is no point in, so that's a reality, so we'll have to live with it. There is no point in cribbing about I do not have good internships in my CV. So I personally believe that you need not have a tier 1 internship or organization, multinational corporations internships, etc. If you have interned at a tier 2, tier 3 firm which is doing good work, then that is equally valuable. And for all you know, the kind of attention as an intern which you will get in a tier 2 or a tier 3 firm will be much more invaluable as compared to a tier 1 firm. Nobody has asked me for my internship certificates to be shown till date. What they have asked in course of discussion is that what was the work that I did. And if I am familiar with and I am able to convey my experience in a more impactful way, and in a much more that demonstrates that I was meticulous and whatever I did I meant business. So that is something which is more important rather than an internship certificate from a firm where I have just enjoyed the free coffee and spent the whole month, which typically tends to happen. Everybody is more concerned about the certificate rather than the quality of experience. It's an opportunity that you are getting for demonstrating your skills for 4 weeks or 6 weeks, whatever the tenure is. So you should not miss out a single minute that you are getting because that's an opportunity to directly interact with the associates or the senior associate or principal associate, or in some cases the partners also, where you are able to make a mark by doing quality work and being sincere about it. So once you are able to demonstrate that, you have crossed the first hurdle. And second is, if there is an opportunity, if they like your work, then automatically you will be the port of first call when they need somebody to be hired. That has typically happened, at least in my team. Or in fact, most of the hirings are based on past internship experiences who have interned with our team, because we have seen their work up close, and we are able to relate to that somebody will be a cultural fit or not in the team, and whether they demonstrate the right characteristics. Now, in coming to the second part of your question, the characteristics, according to me, may vary significantly depending on your role in the team. And I always suggest, don't choose an organization or a firm, rather choose a good mentor, because you may find very difficult, very insecure, and very toxic people. There is no dearth of such people in the market. You may end up working in a fancy place, but at the same time, that aspiration for working at a fancy place will fizzle out and diminish within, say, 6 months' time, if you are exposed to a toxic work culture, and where there is which is full of insecure people who do not want you to grow but want to exploit. So therefore, you should, even if you happen to end up in such a place, be prepared to tolerate it only to a certain extent, and you should jump out of it as soon as the opportunity comes. So don't compromise on that, because the initial foundational years, you should develop an interest in the area of practice rather than you being allergic to those areas of practice just because of some bad experiences. So therefore, don't run after all these. So as I gave the example of don't run after the jargon, similarly, don't run after a tier 1 firm or a multinational corporation. Whatever comes your way, you should grab it and make the most out of it. It's easier said than done. But at the same time, for example, if you do not get an opportunity to intern in a tier 1, that doesn't mean that that's the end of the world. If you are getting a tier 3 firm or a boutique firm which is doing very well in the area of practice which you are interested in, you look at the positives. Like in a large firm, you will have to take that extra effort to make your presence felt. Whereas in a smaller firm, if you're doing well, you will outshine automatically, and you are much more visible, much easier to be spotted and promoted for what you possibly deserve. So just leave it to the destiny in terms of where you end up, but at the same time be honest to yourself and make patient, but be patient and also make sincere efforts, whatever you want to do. But don't be desperate and try to put all your eggs in one basket, saying that no, I'll only intern in tier 1 and I will not do anything else. Then you possibly may end up doing nothing, which is worse than like at least starting off somewhere. So that is something which is very critical and which we lose sight of very easily.
Right, sir.
Thank you so much, sir. Sir, when is it like in your career that you decided you want to go for arbitration? And for the students who are new, like first and second years in the college, how they can like improve themselves and how they can explore in the field, and also simultaneously building a strong CV.
So I personally feel that the internships are the most important thing. As I said, the reason is you are getting a direct foot at the door to demonstrate and demonstrate your skills and interact with the market and the industry. So to that extent, one should be extremely serious and make the most out of that. Any internship opportunity, whether it is a senior counsel or like any opportunity that's coming your way. That is the first and foremost. Second is, if you, again, as I said, second year is too early to decide your specialization. Rather, you should give yourself enough and more opportunities in terms of variety of internships, be it in a corporate setup, a lower court, high court, Supreme Court, whatever possible. And then you decide for yourself which part you are liking it more, which area of law that you are liking it more. Don't go by that herd mentality, again, I would say. Third is, if you still are able to find that what you call that interest in you for a particular field of law, then please do, without compromising on your existing academics, you do read up on portals and forum, wherever you are getting about the field which you are interested in pursuing in the future, and demonstrate your expertise by writing articles, reacting to judgments, criticizing based on adequate research and not just for the sake of doing it. So once you have done that consistently over a period of time, in the fourth year and fifth year, try shaping up or looking out for internships which are in the areas where you want to pursue a career on. So that should be done only at the end of the last 1.5 years, if I may say, the seventh semester and onwards. Those focused internships should be aimed at getting a PPO. And whether you get a PPO or not is secondary. But you should have that mindset that if the team where I'm working is looking for a position to be hired, then they should look no further than me. Nobody beyond me. That should be the approach and the mindset with which you should approach. We do get interns who do not care, like they do not forward or ask for work. Whereas we also get a variety of interns where they are working or associated with other teams. They do not have enough work. They reach out to people, like because they know who is practicing what. You can just Google and find out that in this firm who is practicing on, say, arbitration. You will get the list from the website or from LinkedIn or wherever. They reach out and mail me saying that I am such and such, this, that. I'll just give you an example. I am interning with such and such. Y being X being my buddy. Would your team have some work? I'll be keen on assisting and on matters. So we do assign. If somebody comes up, we'll be more than happy to give work. Many teams, they consider interns to be a burden and they just give clerical work. But you, in that case, don't get disheartened. You should reach out to other people and make the most out of the time that you are getting, rather than saying that mujhe to koi kaam nahi diya. Nobody will come and feed you with work. You have to be enthusiastic and motivated enough that if I have got an opportunity to intern here, I will have to make the most out of it. And how I do it, it has to be your creative sense. So reach out to people, reach out to other partners, reach out to other teams, and there will be somebody or the other you will definitely find who will value the intern, will give enough and more work. And it typically tends to happen that people, and be clear about expectations. What is expected, like research note or judgments just marked or a compilation of cases, what it is. You get clarity from the team in terms of instructions. Second, understand the background of the research rather than just mechanically researching on a proposition. That will give you much more, help you identify much more relevant and give more relevant research. Third is, do some value addition. Even if they have not asked you, prepare a table with the list of judgments, ratio so serial number, name of case, citation, research proposition or the ratio, and the paragraph numbers. Highlight the paragraph numbers so that it's convenient. Prepare a note, one-pager, executive summary sort of thing. So these are value addition which you can do, and understand timelines. Don't just sleep over it. Ask the team team member who is assigning work. Ask them if you can participate, subject to confidentiality, whether you can participate in the hearings or client meetings, etc. In some cases, we do take interns for arbitration hearings or court hearings also. So it depends. So at least you will have to speak up. You can't be silent and expect that people will give you those suggestions. You have to be motivated, and you will have to reach out and ask for whatever is possible out of that opportunity. Try to, and I always prefer physical interns than virtual interns. Many a times the HR team will say of firms that no, it is a virtual internship, we do not have space. Reach out to the team which you have been assigned to. Ask them whether they would prefer a physical internship rather than sitting at your hometown and trying to do it. So reach out, and many a times we have requested the HR, no, we want the intern to be physically present. That physical experience of 4 weeks is invaluable as compared to a virtual internship. So all these things you can consider in terms of, and again, as I said, you can just follow whom you like, whose work you like or you admire. Click of a button, you see videos on topics of your interest, any topic that you want to, any case summary that you want to hear. And you cannot say that I have not read the judgment which has come, say, 10 days back. If you are saying that I want to pursue a career in a particular field, you should be prepared about all of those things.
Thank you so much, sir. I think your answers have been pretty descriptive and enlightening as any student who watches this, and I'm sure they would get a lot of insight as to how they should go about in not only in their law career but in their personal life, or how to navigate an internship. We will take a lot of insights from all of this, and we really hope to continue to connect with not only you but with other alumni over the period of the semesters that we have throughout next year. So any other words that you want to give us, tell us, or any other advice, or before we end the interview?
No, first and foremost, thank you so much for this initiative, and it's a great initiative, and I'm sure you must keep it up in terms of increasing the interaction with the alumni, as I said right at the beginning. Secondly, Thank you for having me as the first speaker. It's indeed a great honor and pleasure interacting with the alma mater and with enthusiastic friends like you. It's always gives us a perspective of how the college is doing, and it's great to see the growth of the college from where it all started. And I'm sure if you reach out to the alumni, we are more than happy to contribute in whatever possible manner and help you all. So you have that advantage and the leverage to reach out to us, and you should make the most out of it. That is something, as I said, guidance and mentorship at any point. It need not be necessarily for a tangible benefit, but generally the interactions will help you in understanding or taking the right decisions and making the right choices at important phases in your career. So thank you once again. And at the end, I would just like to say that don't complicate it, and just keep it very simple. And as long as you are enjoying what you like doing, then automatically rest all falls in place. And it is a very demanding profession. You will have to have some form of hobbies to keep yourself occupied. That is one thing. And once you start enjoying what you're doing, then it is no longer a pain. Rather, you tend to do it much more enthusiastically, and you do not get that fatigue or burnout or whatever terms. So these work-life balance and etc., all those jargon which has come up, that will not distract you anymore. So be honest to yourself and your choices, and just be sincere in whatever you are doing, and have that passion and do it passionately. So that is what I would like to conclude with.
Thank you so much, sir. I know you had a very busy schedule today and you were traveling, but thank you so much. I hope you have a great night ahead.
Thank
Thank you,
you.
sir.
Thank you
Thank you
so
for
much.
joining.
Good night.
Bye bye.
Bye.
Good night.